Good afternoon. Attorney Protective would like to welcome you to today's webinar, Out of Office, the Ethics of Leaving Your Practice. Please reference your materials for information about today's speakers, Erin McCartney and Kate Gould. With that, I would like to introduce you to our first speaker, Erin.
Great. Thanks so much, Michelle. Well, for many attorneys, I think especially a solo attorney, the thought of stepping away from your practice for a week or more to take a vacation can be daunting. Instead of creating a healthy work-life balance or proactively trying to avoid burnout, the vacation often seems to increase the stress and pressure that an attorney faces. As a result, it often feels easier not to take a vacation. But it doesn't have to be this way, and I think with some advanced planning, it is possible to take and actually enjoy a proper vacation. And hopefully Kate and I will be able to give you some tips today to help with that. As far as the agenda, we're going to start talking about attorney burnout and law firm employment trends and some statistics. We're also going to talk about some of the rules that come into play when you are taking a vacation or stepping away from your practice. We'll talk a little bit about succession planning and considerations when identifying a surrogate, and also setting up your surrogate for success. We'll address retirement, what needs to be done. We'll also discuss buying a law practice from a retiring lawyer. And then we'll talk about closing your practice, what needs to be done, and some practical guidance when it comes to that. Finally, we'll finish the presentation with talking about some insurance considerations to closing your practice, and we'll have some time for Q&A. And with that, I'm going to hand it over to Kate to talk about some statistics. Kate?
Great. Thanks so much, Erin. I know I don't have to explain what attorney burnout is. We have all experienced it. Although our jobs can be incredibly fulfilling, being a lawyer is by nature stressful and exhausting. From client demands to excessive hours, many overworked lawyers experience burnout and even mental health struggles. The World Health Organization has identified several signs of burnout, including feelings of exhaustion, pulling away mentally from a job, and work-related cynicism. For some of our colleagues, burnout has unfortunately led to substance abuse, depression, and even suicide. As shown on the slide, a Bloomberg Law survey shows varying degrees of burnout among attorneys, of course peaking at the end of the year in Q4, but always present, showing attorneys feeling burnout about 50% of the time. Female attorneys show a higher rate of burnout than their male counterparts, and caregivers, whether caring for children or aging parents, are more burnout than those who do not have those responsibilities. These figures are probably no surprise to the many working parents and lawyers with important responsibilities outside the office. As lawyers, we are high-achieving individuals who are innately competitive. Qualities like this make us great lawyers, but can also lead to burnout, especially with the seemingly endless to-do list we have besides at our jobs. So, how do we identify burnout and try to avoid or remedy it? Take a moment to assess your current physical and mental state. Are you constantly feeling tired even when getting enough sleep? Are you feeling detached from work and having trouble concentrating at your desk? If you find yourself self-medicating and in a chronic state of stress, you may be closer to burning out than you think. Many firms recognize this and try to accommodate their lawyers to the extent possible. Hybrid work schedules have become more commonplace, and some lawyers work on a part-time basis. Still, a recent 2022 Legal Trends report found that even with certain accommodations, 86% of lawyers work outside the typical 8-to-5 workday, and 73% work outside of regular business days. In other words, most of us are billing hours before the workday starts for most people, and at some point during the weekend as well. The ABA recently highlighted a New Jersey 2022 survey which showed that 28% of its state's lawyers have considered leaving the profession due to burnout or stress. The statistics in Massachusetts are even higher, with 75% of the lawyers surveyed reporting burnout and almost half stating that they have thought about leaving the job or profession itself. Quite frankly, the work we do is hard and demanding, and these statistics highlight the need to take a break. Erin is going to discuss the importance of vacation and getting away from your desk, along with certain ethical guidelines to keep in mind. But if you do not have a trip on the horizon, remember you can try to avoid burnout by practicing some self-care. Make sure you get enough sleep, exercise when possible, spend time in nature, and find hobbies outside of work. By implementing some healthy habits, you can ensure you are your best self and the best lawyer for your clients. Erin?
Great. Thanks so much, Kate. So Kate talked about attorney burnout, and I think we would all agree this is a real thing. And that's why it is so important to step away and recharge every now and again. So next we're going to talk about vacation mode activated, and although that sounds like a lot of fun, of course there are ethical considerations to taking time away from the office. While we cannot shirk our professional responsibilities, we can and we should periodically step away. Your duty as an attorney requires competence, diligence, and proper client communication. These duties can be at risk of compromise during any disengagement from your practice. However, with proper planning, these risks can be avoided. So I'm going to quickly cover the applicable ethics rules and then provide some realistic and hopefully helpful tips for those who are getting the itch to plan a vacation. So first, Rule 1.1 of the model rules requires competence. Whether away on vacation or recovering from a surgery, lawyers remain accountable to their clients to provide competent representation during any absence. So although you may be enjoying a Mai Tai on the beach, you are still accountable for the legal services for which you were engaged, and you must perform these services competently. Unfortunately, despite adequate planning, some emergencies cannot be anticipated. Therefore, as the best practice tip on your slide states, while unplugging, it may be necessary to maintain some level of contact with your office to ensure this duty is fulfilled. And we're going to get into this in a little bit more when we address tips for maximizing your time out of the office. But next, we're going to talk about Rule 1.3 of the model rules, which states, a lawyer shall act with reasonable diligence and promptness in representing a client. Just like the requirement to be competent, a lawyer's duty to remain diligent in the representation is not somehow suspended during vacation or a short-term absence from the office. In the litigation world in particular, calls or inquiries from the court should be promptly addressed by you or another attorney in your absence who's familiar with the case. Diligence means staying organized in order to meet all deadlines. In other words, not dropping the ball on any client needs. Being on vacation is not an excuse. You cannot simply check out and ignore deadlines during this time. Finally, under Rule 1.4 of the model rules, lawyers are required to keep the lines of communication with their clients open at all times. They must keep their clients reasonably informed about the status of their case and comply with reasonable requests for information. Just like the other ethics rules, an attorney's duty to communicate does not cease to exist because you're on vacation. As an attorney, you are still required to keep a client reasonably informed about significant developments relating to the representation. So failure to communicate with or inattention to the needs of a client may constitute grounds for discipline. Now, honestly, we've all had experience with some clients that can be a bit more high maintenance than others, so they require more attention and more frequent communication. But much to the chagrin of some clients, you aren't on call at all times to answer their burning legal questions. The reason that I also keep emphasizing the word reasonable is because the standard is reasonableness. That being said, by providing a timeline for when your clients can expect to hear from you or someone in your office, you can satisfy this reasonableness standard. But ethically, you cannot cut off all means of communication with them. This is why setting boundaries and tempering client expectations for a vacation from the office is so important. You absolutely can enjoy your time away while fulfilling your professional responsibilities, but you may need to do just a little bit of pre-vacation planning and strategizing. So let's look at some best practice tips for maximizing your time out of the office. Although completely unplugging may not be possible, there are some pre-vacation strategies that you can implement so you can return to the office feeling renewed and refreshed. First, you want to notify clients. By letting your clients know that you'll be away, you will likely avoid any interruption on your trip. chances are your client will appreciate the fact that you gave them advance notice and then respect that boundary. We just discussed Rule 1.4 and how lawyers need to communicate with their clients promptly. So ensuring clients are still getting timely updates on their cases, and if not from you, then another staff member or a colleague, this is going to be key. You can always suggest that they contact your assistant who can help determine whether something is an emergency or if you can address the matter when you return. It's up to you how much you want to stay connected, if at all, but you'll probably want to include something about your availability when you notify them. Of course, you'll also need to tell your staff, your firm partners, and anyone else you work with that you'll be taking a vacation. Give clear instructions for work that needs to be completed in your absence, contact information for the lawyer providing coverage in your absence, and we'll talk about vacation buddies in just a minute, but also how to contact you on vacation and when it isn't appropriate to do so. Clients may think that something's an emergency when it's not. So make sure your assistant or the attorney covering for you can determine the difference. My advice is tell everyone, as soon as you settle on dates, start giving notice as soon as possible to courts, coworkers, or other counsel, as well as clients, to avoid potential scheduling conflicts. Even if your trip is months away, you'd rather err on the side of more notice than not enough, though you still may want to remind them of your absence as the date gets a little bit closer. Next, coordinate with your legal staff and fellow attorneys. Ask that your legal assistant be in the office when you're away. By having someone familiar with your cases in the office, you and your clients will have greater peace of mind that nothing will slip through the cracks while you're gone. Review your bills. If your billing cycle falls around your vacation, make sure you review your bills ahead of time so they are mailed in accordance with the usual monthly schedule. Your client is likely expecting a bill. If you ever take AppPro's billing webinar, you will hear me say over and over again that consistent billing procedures could be the difference between getting paid and not getting paid. Plus, it's one less thing that you'll need to add to your to-do list when you return. Be sure to timely mark out your vacation time on your calendar so nothing is scheduled on your anticipated days out of the office. Also, think about what will happen immediately before and after your return. If at all possible, set aside some time to plow through work and tie up loose ends before you leave. This includes both finishing up outstanding tasks and providing information to others so they can complete work for you. The more organized your caseload is, the more you'll be able to enjoy your vacation. In terms of your return, avoid setting deadlines for the first 2 or 3 days that you're back in the office. You'll likely want to be catching up and reviewing what you've missed during this time, not rushing to meet a deadline immediately after returning from your time off. Also, it may be hard to relax on vacation knowing that there's a hearing or a client meeting scheduled on the day you return to the office. So upon your return, think about reserving a day to catch up on email and voicemails. Plus, with flights these days, you never know if you're going to be delayed or canceled, so you might just want to add in that extra cushion. Also, set your away messages. Record a voicemail message advising of the dates that you'll be out of the office and who can be contacted for immediate assistance. Likewise, setting an automatic email reply with the same information and instructions is an easy way to set expectations as to when your clients will hear from you upon return from vacation. I usually write that I will have no access or limited access to email and that I'm not checking email while I'm away, and here's the person to contact in my absence. Lucky for Kate, that's usually her. But these things might seem obvious, but a correctly worded out-of-office message can save you a number of stresses, namely from missed requests on urgent matters. This can also help maintain your client's faith in your ability to handle their case, cementing your representation and reputation as a reliable lawyer. So craft a message that's relevant, informative, and polite, but also word it in a way that it makes it clear that you're only available to respond to serious emergencies, and then always include an alternative contact for urgent matters. Short-term coverage. As a solo practitioner, you may have a reciprocal arrangement with a colleague to cover each other's practices when you're out of town. Be sure to brief them on anything you anticipate might come up and let them know under what circumstances to reach you when you're gone. I can't stress enough that one of the keys to peace of mind on vacation is utilizing a vacation buddy. In choosing a vacation buddy, there's several things to consider. One important factor that should go without saying is that your vacation buddy should be someone you know well enough to determine his or her trustworthiness and accountability. If you think that you will spend your whole vacation worrying about whether a particular potential vacation buddy is staying on top of things, this is probably the wrong person for you. Equally important is to find a vacation buddy in your area of practice. Once you've selected a potential vacation buddy, be sure to be clear about what you are needing them to do. Are they checking your case online dockets, or checking your mail and scanning and emailing anything that's urgent? Once you target your vacation buddy and they've agreed to fulfill that role, decide how formal you both want this relationship to be, whether you wish to put your arrangement in writing. This decision will be driven in large part about what your vacation buddy will be doing and how long you are planning to be out of the office. If you only need your vacation buddy to check the online dockets for your cases, you can probably keep this relationship pretty informal. On the other hand, if the coverage that you're looking for is more involved or for a fairly long duration, putting the specifics in writing will help prevent any misunderstandings about what the expectations are. I would also recommend mapping and strategizing your current cases. And what I mean by this is that it can be beneficial to map out the potential timelines for your open cases and then create a case flow that's favorable to your vacation time frame. For example, you may have an opening brief that is due a couple of days into your vacation. Based on your current workload, you may be in a position to file it before you leave. Now, while you will undoubtedly end up with a couple of late nights before any vacation, implementing these tips and strategies can give you peace of mind while enjoying your time off. As with most things, striking that balance between going off the grid and being available depends on the lawyer and their practice. Some lawyers may be completely comfortable allowing their associates to handle their files in their absence. Others may struggle not to answer every email received while sitting on the beach. So think about what works best for you. That being said, it is possible to take time to relax and recharge while adhering to these ethical obligations that we just talked about. Kate, if there's anything you want to add, please do so. But if not, I'll pass it back over to you to talk about succession planning.
Thanks, Erin. No, I think that's really great advice, and I hope everyone takes advantage of it and gets out of town. We are going to switch gears now a bit and dive into succession planning and the need to have a plan. Although none of us want to think about our death or potential incapacity, it is our professional responsibility to put some procedures or people in place to step in if necessary. For some practitioners, this may be a surrogate attorney. You'll see the rule on your screen, which contemplates the designation of a surrogate attorney. I should say this is the comment, actually. A surrogate attorney is a successor designated to take action to preserve and handle the law practice of the now deceased or incapacitated attorney. As states continue to develop their own rules with respect to surrogate counsel and succession planning, the ABA provides this helpful guidance, and that's the comment you see here on your screen. It states that the duty of diligence may require a sole practitioner to designate another attorney to review files, notify clients, and determine the need for immediate protective action in the event of the death or disability of the sole practitioner. Practically speaking, the surrogate attorney should be someone who is familiar with your practice areas and that can competently step in and take over your cases for the short term, if not actually retained by your clients. The attorney should have the capacity and time to effectively run your practice or assist in winding it down. Oftentimes, this can be a reciprocal arrangement between practitioners. You will also want to consider their age and how long they expect to practice to hopefully give your clients the continuity and representation they deserve. Having someone ready to take the reins for years to come not only gives your clients peace of mind, it's also often cost-effective for them. You'll also want to check for any conflicts to the extent you can. We want to look at some state law examples next. As you can imagine, states have different rules for succession planning. While designating a surrogate attorney is not yet required in every state, several jurisdictions mandate some form of succession planning. If we do not review your state's rules here, be sure to check your jurisdiction to ensure compliance. But I do want to give a brief overview of some states' rules to give you a flavor of what is being required. As we look at the state laws, I'm proud to say as an Indiana barred attorney that the ABA has identified Indiana's rule as the gold standard for attorney surrogate rules. The rule provides that at the time of completing annual registration, a lawyer may designate a surrogate attorney by specifying the attorney number of the surrogate and certifying that the surrogate has agreed to the designation in a writing in possession of both the lawyer and the surrogate. So in Indiana, when an attorney dies or becomes incapacitated, a verified petition is filed with the Supreme Court and served upon the designated attorney surrogate. The court may then appoint the attorney surrogate to continue the deceased or incapacitated lawyer's practice. Indiana's rule is quite comprehensive to the point of actually itemizing certain actions the surrogate attorney may take upon appointment, including taking possession of the files and records of the practice, applying for extensions of time, and notifying clients for purposes of the clients collecting their files and hiring replacement counsel if necessary. The rule further provides that the court granting the petition for appointment of surrogate counsel has jurisdiction over the closed files of the attorney and may issue orders with respect to those files, including for destruction, alleviating the potential headache of the surrogate attorney and perhaps even the lawyer's heirs as they wind down the practice. The rule further provides that certain deadlines and statutes of limitations are automatically extended for 120 days from the date of filing the petition. And I actually checked the Southern District of Indiana, their website today. This is one of our federal courts, and saw that they have forms available, including the notice to the clerk, where if you are the surrogate, you can state the reason for the unavailability of the subject lawyer. In addition to the death and disability of the lawyer as reasons for the unavailability, disappearance and disbarment were also listed as justification for the surrogate to take over. So again, these are circumstances that none of us want to think about, but it's nice to know that there are these safeguards in place. I would expect other states to follow suit and establish these surrogacy processes, and some already have, so I want to review those now. Looking at Florida, Florida is one state that mandates the designation of a surrogate attorney. Through the state bar registration process, Florida attorneys designate an inventory attorney to take over if an attorney dies or becomes incapacitated. And the rule provides that the attorney does just that. They inventory the files of the subject attorney and take such action as seems indicated to protect the client's interests. Next is South Carolina. South Carolina requires its attorneys to prepare detailed succession plans specifying what steps must be taken in the event of their death or disability from practicing law. The rule contemplates designation of a successor lawyer and even provides that the designation plan may set out a fee-sharing arrangement for the successor attorney. Going down the list is Illinois. Illinois requires active practicing attorneys to state in their annual registration whether their organization or firm has a written succession plan. However, the rule does not require that such a plan exist. Looking at New York, the New York Rule of Professional Conduct regarding diligence, that being Rule 1.3 and its Comment 5, mirrors the ABA rule we just reviewed in stating that to avoid possible prejudice to client interests, a sole practitioner is well advised to prepare a plan that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine whether there is a need for immediate protective action. While the designation of a successor attorney is not required, it is certainly recommended. Next, looking at Texas. The Texas State Bar urges its attorneys to develop succession plans and even designate a custodian attorney in advance. Texas practitioners can use the State Bar portal to designate a custodian attorney. The custodian attorney does not inherit the lawyer's law practice, but it is anticipated they will serve in a more limited role to wind down the practice. Texas likewise provides that upon notice of the unexpected death of a busy solo practitioner, and this is in the absence of any succession plan, the Office of Chief Disciplinary Counsel or other interested person may petition the court to assume jurisdiction of the lawyer's practice. Pursuant to these rules, the court will appoint a Texas attorney to serve as a custodian attorney. Finally, I want to mention California, and then though it's not highlighted on your map, I mention it because I feel like California sometimes gets a bad rap in other parts of the country, and some practitioners are hesitant to even cite opinions out of the state. But when it comes to attorney surrogates and succession planning, the state takes a very practical approach. The California State Bar has an attorney surrogacy program, which provides a model agreement for the designation of an attorney to step in if a lawyer dies or becomes incapacitated. In fact, it provides a sample agreement which details the responsibilities of the lawyers, and that's titled Agreement to Close Law Practice in the Future. And this is for purposes of compliance with the California Business and Professions Code and the Probate Code. Now, I'm reviewing just a few state rules concerning successor attorneys and succession planning. You can see how different states have addressed the issue. Again, in the busy day-to-day work of a law firm, succession planning may not be top of mind, but it's certainly something to start thinking about. But if you haven't, you certainly aren't alone. According to a recent Thomson Reuters survey of U.S. mid-sized law firms, the legal industry is lagging far behind in terms of leadership and firm succession preparedness. In fact, according to their survey, only 40% of firms said they felt prepared to deal with the retirement and succession of partners, while 61% said they were concerned about their lack of preparedness. In addition, only 37% of surveyed firms said they had a formal succession planning process in place or were in the process of creating one. The remaining 43% surveyed had an informal process or didn't even have a succession plan or planning on their radar. Ida Abbott, who's the president of a consulting firm and a fellow with the American Bar Foundation, has said that succession planning is becoming really urgent because we all know that about a third of equity partners are at retirement age, and we're really looking at the potential for a major outflux. So even firms with mandatory retirement run into a lot of problems because lawyers tend to not believe it's actually going to happen to them, and they delay talking about it or not doing anything about it until the issue is right in front of them. So again, just considering these statistics, if you don't have a plan yet, you certainly aren't the only one. I would encourage you to start with the ABA materials on succession planning. You will find state-specific resources as well as their recommendations for a comprehensive succession plan, which should include at a minimum written instructions concerning how and where client information is stored, such as bank and other account details, instructions concerning disposition of closed client files, information about law office equipment leases or other contracts, and the payment of current liabilities, practical information such as instructions to gain access to computer and voicemail passwords, and details about how the successor will be compensated. Let's talk about how we can set up your surrogate for success if you have one. Quite simply, effectively and efficiently running your practice is the best way to prepare your surrogate attorney in the event they will need to step in. Regardless of the size of your practice, implementing and documenting consistent office procedures and protocols is paramount. By developing a manual or simple training materials that clearly communicate how to use the firm's calendaring system, the conflict procedure, and accounting systems or billing software, the surrogate attorney should be able to seamlessly transition into your practice. Perhaps the most important means to ensure a smooth transition is maintaining an active file list and calendar. The surrogate attorney's first order of business will likely be reviewing your file list and cross-checking it against the calendar to ensure no court dates or deadlines are missed. Assistants and paralegals may assist with keeping you organized on a day-to-day basis, but they should also be well-equipped to assist the surrogate attorney. Quite frankly, your practice, and maybe even your estate, is at risk if your files are poorly documented or incomplete. Make sure you develop and implement best practices in terms of organization now for yourself and your designated surrogate attorney. With respect to communication, the fee agreement is an effective means to advise clients who they may be in contact with in the event of your death or incapacity. Consider adding a provision to your fee agreement with the surrogate's name and contact information. Most clients will appreciate the proactive steps you've taken in protecting their interests should you be unable to continue to represent them. Invite a conversation about it as well. Explain that they will still have the option of selecting another attorney, and if they want to use the surrogate attorney you have identified, the surrogate will perform a conflicts check. In other words, by signing the fee agreement, they aren't agreeing to be represented by someone else. It is more for their convenience and to ensure that their case does not inadvertently fall through the cracks if you unexpectedly die or are unavailable. Before we move to the next section, Erin, do you have anything to add?
No, I think you covered everything. So there's some great tips up there for setting your surrogate up for success. So switching gears, we're now going to talk about retirement. So you'll see the question on your slide says, why is closing down a law practice any different than closing down any other business? Well, as a lawyer, we have more ethical considerations than any other profession. So that is why. And we went through some of these ethics rules earlier in the presentation. But realistically, what needs to be done? I have some resources here on the slide, and I recommend that if you are planning to retire, to contact your local bar for additional resources. You'll see here I listed the Florida Bar. They have a great checklist for lawyer retirement, law office closure, and law firm dissolution, and that's at that site right there, the Legal Fuel site. You'll see California Bar has resources. New York has similar ones. And we have great resources. Kate and I actually spent a lot of time putting great resources together over the past couple of years because this is a question that we get asked a lot about, whether on our risk management hotline or when we're presenting at different state bar seminars. We always get asked questions about retirement and what needs to be done. And every lawyer loves a good checklist. So if you go on our site, you'll see that we have great resources there under vacation, retirement, and succession planning on our attorneyprotective.com website under Protect Your Practice. So there's additional resources there as well. So moving on, planning retirement, practically speaking, what needs to be done? Well, first, you want to stop accepting new cases. Even before you begin the process of winding down your law firm, stop accepting new cases. Each new client you consult could become a potential conflict for when you close your law firm. So speak to other attorneys about referrals. Referring cases out could garner some income even as you begin closing your law firm. Also, set a date. Closing a law practice does not happen overnight. It will likely require action over several months. So pick a date based on your active case files and their already scheduled deadlines. And pick a date based on your ability to secure permission to withdraw while trying your best to set the client up for a successful transition. And this is easier said than done. So I recommend mapping out a retirement timeline. This will give you an idea of what your rough time frame for retiring might be. Start by compiling a detailed list of all your open cases. Next, estimate a timeline for finishing the remaining work on each case. You may want to do a range for each case. Figure out the timing, what it would look like if the case moved at the average rate of your other or similar cases, as well as figure out the timing if it moves more slowly than typical. Once you've done this for all of your open cases, you'll have an idea of when, approximately, you would first be in a position to retire from your practice. You may find that your first opportunity to retire based on your current caseload is sooner than you expected or wanted. Another possible outcome of mapping your timeline to retirement is that you find out it's a little bit further out than you had hoped for. But once you're able to pick a date, a future date, next begins the process of closing your law firm one step at a time. So once you've set a date, it's time to start informing clients that you are closing your legal practice. Contact your long-term clients, discuss any pending cases and their options, such as new counsel, attorney fees due, or refund of fees if you are not going to be able to complete the work when payment's already been received from the client, of course. From a risk management perspective, it's important to document all proper communication to clients advising that your firm is closing, because being able to produce clear documentation about when and how you told clients about your law firm closure will help if clients fail to take steps to protect their own interests. Attorney closure letters should be used to convey the proper steps clients should take surrounding the law firm's impending closure. I recommend looking at sample dissolution letters and then tailor it to your needs. These can be found on your state and local bar association websites. There are many good examples of law firm dissolution letters. You'll see on our next slide, I actually have a sample there. But at a minimum, your letter should inform clients of your legal practice's closure date, the status of your client's case with you, how you'll handle the transfer of your client's files, and if you hold funds in a trust for your client, your law firm closing letter should also discuss the amounts and how refunds will be handled. You also want to ascertain the status of client files. And what I mean by that is each open file needs to be considered with regard to its deadlines and its fee arrangements. Remember, if the file is being either given to the client or the client's new attorney, to stress in writing that time is of the essence. In cases where the client is obtaining new counsel, be certain a substitution of attorney is filed. Once clients are informed, start packaging their files for transition. You should have two goals when you're packaging a file. One, make it easy for the client or the future lawyer to continue pursuing the interest. Two, be sure to remove any document of value from your archives. Kate's actually going to talk about this in a little bit, so I'm not going to steal her thunder here, but client items with intrinsic value should never be destroyed. And then be sure to retain a copy of the file and written acknowledgement from the client or the new attorney that the file has been transferred. After obtaining the client's consent, file a motion and order to withdraw from any pending litigation. Also, return closed files and original documents. A retiring attorney is likely to have boxes and boxes of closed case or client files. Kate and I get asked on our risk management hotline all the time, how long do I need to keep a closed case file? Well, different states have different requirements, and Kate is going to actually cover this in just a little bit more detail in a bit. So we talked earlier about the benefits of mapping out a timeline for retirement. Mapping out a timeline also helps provide a time frame to manage the renewal of practice-related contracts, such as office space leases, your Westlaw LexisNexis contracts, your telephone contracts, your domain name rental, all of this stuff. These renewal dates should be added to your timeline because you will need to reach out to your landlord and vendors to finalize arrangements. You'll need to terminate your lease for your office space. You'll also need to terminate equipment leases and make arrangements for the removal of these items. For any contract that will extend beyond the close of your practice, you may need to negotiate an early termination or see if you can switch to a month-to-month plan. Also, be aware of practice-related contracts that are tied to your credit card and renew automatically. Also, your utilities and services, they need to be canceled. And, of course, any office subscriptions and other memberships. So it's a good idea to extend some contracts, such as those for your business email or your website or your telephone, so that you can provide notice of your retirement, as well as how to contact you regarding a closed case. Consider letting these outgoing messages run for several months after you've closed your practice. If you have a website, you might consider reducing it just to one page, which is enough information to inform those visiting your site of your retirement and their options. Also, part of submitting your notice for retirement includes updating your status in the attorney information system. You can change your status from active to retired, but if you think that you may practice again in the future, you can change your status to inactive instead of retired. As always, though, check in with your local bar association about requirements and then notify any insurance carriers about your retirement as well. The risk covered by malpractice insurance, it doesn't go away just because your law firm has closed. Discovery periods and statute of limitations for malpractice claims will continue long after your law firm closure. So a lawyer leaving the legal profession should contact their insurer to discuss continuing coverage even after the closure of the law firm or the addition of an ERE, which is an extended reporting endorsement or tail coverage, to the policy prior to closing the firm. And for those of you who don't know what an ERE is or tail coverage, we're actually going to talk about this in a little bit more detail at the end of the presentation. So we'll get to that in just a bit if you're not familiar with those terms. But essentially, walking away from a law practice, it's not as easy as turning off the lights, locking the door. It takes a bit of planning. And the more organized your office is, the simpler these steps are going to be. On the next slide, you'll just see I put on here a sample letter notifying the client of your retirement. This is actually from the South Carolina Bar. I think it's a great template. So if you are looking for a template to use, and then of course tailor it to your own needs, this is one that I would recommend. And again, it can be found on the South Carolina Bar website. But next, let's talk about buying a law practice from a retired lawyer. So Kate and I wanted this webinar to help lawyers think about retirement, but also share some tips for those lawyers that are still looking to grow their practice. With a lot of lawyers retiring, there is great opportunity for younger lawyers to expand their practice. Whether you've started a law practice and are looking to expand or are thinking about leaving a large firm and venturing out on your own, buying a law practice might be right for you. So regardless of where you are in your career, it can be much easier and sometimes a lot more cost-effective to buy a law practice than it is to start one on your own. Many attorneys don't even consider purchasing a law practice because they don't realize they can, or they don't know where to start the process. So where to find a law practice for sale? Unlike a house or any real estate, you're not going to find a for sale sign usually outside of a law firm, even when the owner of the firm wants to sell their practice. So how do you find a firm that you can purchase? One organic path is to network with older attorneys who may be looking toward a transition soon. You can also look at registries created for this niche. There's a few. There's one, Private Practice Transitions. Another one is Biz Buy Sell. Some registries even provide support by making experts available to answer your questions, but I would really recommend reaching out to your state bar associations. They're a valuable resource, and they can guide and support lawyers when choosing which firm to buy and how much to pay for it. For example, I know Washington State Bar, they offer a career center that you can filter to show practice transition. And with this filter, you can actually find attorneys who are potentially retiring or looking for buyers. The Oregon State Bar also has a forum where members can post or inquire about firms for sale. So again, I recommend contacting your state bar if you are looking to purchase a law firm. If you are considering buying a firm, you also want to consider the area of practice, the client base, and the branding of the firm. Of course, you don't want to buy a commercial law firm if your area of practice is personal injury, right? So to ensure that you target firms that most align with your experience and your goals, you need to first consider your long-term goals. What type of attorney do you want to be? Where do you want your practice to be? In what areas of practice do you want to continue to practice or grow? It's important to review the existing clients of a firm for sale to gain an understanding of the needs being met and whether those clients seem like ones with whom you'd have good chemistry. Also, do your due diligence. You should review financials, tax returns, and cash flow projections, and meet with the owners and the key staff. While making the decision to purchase a firm is an important step, due diligence will be the most time-consuming in actually purchasing and taking over a practice. And then when conducting your due diligence, you should engage your financial advisor to address whether and how the purchase of the firm will help you with your long-term financial goals. But you also want to loop in your CPA to advise on the tax benefits of purchasing a law firm, and an advisor who can help you with the deal structure. There are also ethical considerations to buying a law practice. You want to review Rule 1.17, which addresses the sale of a law practice and states that the law firm seller must make clients of the prospective firm aware of the sale and have the right to choose another counsel. Most states have similar requirements, but the rules of buying firms can vary between jurisdictions, so make sure to check into yours before buying a law practice. And then finally, create a transition plan. After the sale, there will be a transition period. During the transition phase, the seller should transfer the knowledge base, key clientele, referral networks, and other elements to give you the best chance of success in your new firm. And if you are looking for more resources on buying a firm, also please visit the APRO website because we have additional resources there. So with that, Kate, I'm going to toss it back over to you to talk about closing your practice.
Okay, perfect. Yeah, we're going to piggyback off some of the comments and guidance that Erin offered and touch on some topics related to closing your practice. We'll first jump into file retention and destruction, look at dissolution and tax considerations, and see what the rules of professional conduct require concerning trust accounting and record keeping. So first, with respect to file retention and destruction, these are difficult for many lawyers and law firms. As Erin mentioned, we receive many inquiries on the APRO Risk Management Hotline regarding file retention. And quite frankly, I think most of us would admit we have trouble letting go of old files, despite rarely, if ever, even referencing them. There's just something about giving the okay to send it to the shredder that gives us pause for fear of violating the rules related to file retention and destruction, or thinking we're going to need something the minute we approve the file's destruction. Of course, when closing or selling your practice, there are practical considerations of file storage or wanting to avoid transferring an abundance of old files to another attorney. So where do you start? First, follow your policy if you have one. Understandably, for an older closed file, you may have forgotten the file retention policy agreed to in the engagement letter and hopefully reiterated in your closing letter. Consult this correspondence when you pull the file to determine whether you need to retain the file and transfer it or if you can destroy it. If destruction is appropriate, see if you previously agreed to provide notice and opportunity for your client to retrieve their file prior to your destruction. You can include a destruction notice in your letter about closing your practice, which may prompt your client to pick up their file, alleviating the need to further question whether you need to possibly transfer it. In the sample retirement letter that Erin spoke about, you'll also find language concerning file retention and destruction. If you do not have a firm policy for file retention or destruction, you'll be happy to hear that the ABA model rules offer some helpful guidance concerning a lawyer's obligation to maintain client information to fulfill their ethical duties. Model Rule 1.16b provides that upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect a client's interests, such as surrendering papers and property to which the client is entitled. While this isn't a hard and fast rule for the number of years a file must be retained, this is instructive. First, it does not require a firm to keep all files indefinitely, and secondly, it contemplates the possibility of returning the file to the client, while at the same time accomplishing the goal of clearing out old files. Of course, this comes into play when you're in the process of closing your firm. If nothing else, it should give you some assurance that you do not need to stack old client files in your garage, and you can comply with the rule by reaching out to clients to pick up their file if you don't have a policy. If your client doesn't get back to you about picking up their file, run through a quick checklist before shredding the file. First, ask, what documents are in the file? So as you probably know, original documents such as wills, deeds, and certain contracts should be maintained, and their destruction will likely need to be evaluated on a case-by-case basis. Some states will dictate a minimum number of years to retain the document, but you should also consider the lifespan of the document as well. If the contract term has not expired, it would be premature to dispose of the document. If you're not transferring this file, you may want to hold on to it. Next, ask, is there pending litigation? Perhaps another box to check before you destroy a file should be whether a litigation hold exists. If you received a litigation hold letter, you should check the status of a litigation or any government investigation before evaluating the file for destruction. Maintain the file in its entirety or transfer it, because violation of a litigation hold letter could have serious evidentiary consequences for your client. Next, consider the statute of limitations for legal malpractice. Be sure and check your state statute of limitations for legal malpractice claims as the minimum length of time to retain the file. Your entire file, including all your notes and draft documents, may be your best defense in a malpractice action. So how do states address client file retention? Not surprisingly, individual states and their bar associations have different opinions when it comes to file retention. Although California courts have not yet addressed the retention period, several California bar associations have provided guidance. For example, the Los Angeles County Bar Association opines that a civil attorney should retain potentially significant papers and property in the former client's file for at least 5 years. This is consistent with the California Rule of Professional Conduct, which requires an attorney to maintain all records of client funds and other properties that the client provided to the attorney for at least 5 years. In Alabama, an Alabama State Bar Association advisory opinion provides that a lawyer should maintain a copy of the client's file for a minimum of 6 years from the termination of the representation or conclusion of the matter. The opinion cautions that 6 years is the absolute minimum period, and certain circumstances may require a longer or even indefinite period of retention. Such circumstances could include files related to minors, probate matters, taxes, and transactional matters, which require lawyers to maintain a file until its contents are rendered obsolete by the passage of time and serve no useful purpose to the client or lawyer. The general rule for file retention in Illinois is 7 years. Illinois Supreme Court Rule 769 provides that all financial records related to the attorney's practice, including bank statements, time and billing records, checks, journals, financial statements, and tax returns, among other financial documents, must be maintained in a physical or electronic file for at least 7 years. While the rule doesn't encompass all potential components of a client file, most Illinois attorneys allow 7 years to pass before considering whether they must retain or can destroy the file. While state legislatures and bar associations perhaps do not offer the bright line rules we would like, they do provide helpful guidance to practitioners wanting to clear their file cabinets of old client files, especially when shutting down their practice. As a rule of thumb, consider the timeframes provided by your jurisdiction as the minimum length to keep a client file. Then exercise good judgment when considering questions of file retention or destruction. Best to err on the side of caution and keep the file physically intact or transfer it to the attorney taking over to maintain an electronic copy if your client does not retrieve it. So I want to quickly turn to dissolution and tax implications. So if you decided to close your practice, does this mean you have to dissolve it? As I mentioned in a prior section, closing your practice could also involve selling it to another attorney or firm. So while a complete dissolution may be appropriate for some, you may have other options to explore, whether a buyout, acquisition, or merger. If a dissolution is the right path to take, follow the dissolution procedure in your partnership agreement. Of course, of the utmost importance, is that properly notifying your clients, as we've discussed. The attorney-client relationship distinguishes closing a law firm from shutting down other businesses, as we have ethical obligations to meet. We must communicate with the client, deal with the client trust accounts appropriately, and remain diligent as the deadline to close the firm nears. Be mindful of the timing for your clients, too. You need to give reasonable notice to them that you are terminating representation because you're closing the firm so they can retain other counsel. You'll want to refund any retainers for fees that have not been earned, and be sure to keep complete records of client account, funds, and property for at least 5 years, as we discussed, after ending representation. With regard to taxes, be sure and work with your accountant to tie up all loose ends. However, note that in general, the IRS advises dissolving firms to file your annual return for the year you dissolve the firm, file your employment tax returns, make any final federal tax deposits, and issue final withholding information and wages to employees, among other obligations. Quickly, with respect to trust accounting record keeping, I just mentioned keeping complete records of account funds and property for 5 years after the representation ends. And this next slide shows the Model Rule of Professional Conduct, Rule 1.15, but also check your state's rule and treat that 5 years as the minimum deadline. I'm going to turn it over to Erin for some final comments about insurance.
Great. Thanks, Kate. Well, we saved the best for last. So insurance considerations to closing your practice. And for those who have never purchased a legal malpractice policy or never read their APRO policy, this is how legal malpractice insurance typically works. Professional liability policies afford coverage for 1 year at a time. So in order for an attorney to have coverage in place at all times, a policy must be obtained every year. Continuity of coverage is really important in a claims-made coverage. When an attorney changes firms or becomes a judge, retires, or exits private practice for any reason, an ERE becomes available and necessary. And I referenced this earlier, but an ERE is an extended reporting endorsement. This also is known sometimes as tail coverage. This is needed because of the claims-made nature of a lawyer's professional liability insurance policy. A claims-made policy provides coverage for alleged actions that occurred during the time the policy was in effect. So in other words, the coverage provided in a claims-made policy, it ends when the coverage terminates. Your ERE is not a separate policy. Instead, the endorsement extends the terms and conditions of the prior existing policy and allows for an additional period of time for a claim to be reported to the carrier. In other words, it allows you to report claims to the insurer after the policy has expired or been canceled. But this means there's no coverage available for a negligent act or omission which occurs during the time the ERE is in effect. So if you're doing pro bono work for a friend of yours after you retire, this is not going to be covered under the endorsement. If you think you need an ERE or you have more questions, please contact APRO, or if you're looking for more information, on our website under Find the Right Coverage, you'll see we have a great resource called the Legal Malpractice 101 Guide, and it clearly explains all of these terms. But just to wrap this up, because I know we're at the 60-minute mark, the risk covered by malpractice insurance, it doesn't go away just because your law firm is closed. Discovery periods and statute of limitations for malpractice claims will continue long after your law firm closure. So a lawyer leaving the legal profession should contact their insurer to discuss continuing coverage and the addition of an ERE to their policy prior to closing the law firm. So with that, I'm going to toss it over to Michelle to open up our Q&A. Michelle?
With that, let's look at a few questions here. Let's see. Should you include a designation of your successor attorney in your fee agreement so the client agrees in advance that if you are unavailable or incompetent, then the new attorney is retained?
I'll take this one, Erin. I briefly touched on this during the webinar. We would recommend this. Even if the client ultimately decides to hire someone else, you can at least provide them this continuity in representation if they need it. And I think it's a really nice just customer service opportunity. So yes, I would say to include that designation in your fee agreement.
Let's see, here's another question. Is it appropriate to add your surrogate attorney as an authorized signer on trust and operating accounts?
I can take this one too, Erin, since I discussed this topic. I think depending on your circumstances, this might be appropriate, especially if you do not have support staff or an office manager. Adding the surrogate as an authorized signer would certainly help sort things out more quickly in the event of your death or incapacity. Would you agree, Erin?
I would. I think that you answered that great.
In my standard retainer agreement, I state that I can destroy the closed file after 3 years without notifying the client. I plan to retire and close my practice in 2 years. What do you recommend about closed client files that are less than 3 years old?
I'm not surprised we got a question on this because Kate and I had said this throughout the presentation. This is a question we get asked a lot, and I think Kate did talk about this a little bit and had said that different states do have different requirements. My recommendation is always keep the file for 7 years, and I say this for 2 reasons. One is to protect yourself from potential malpractice claims. Keeping the file for 7 years, it allows you to defend against potential claims that might arise after the representation ends, as the statute of limitations on a lot of common claims would have run out by then. By retaining the files, you can also reconstruct the work you did for the client should a malpractice claim arise, and then that way you're in a much better position to defend yourself. The second reason that I would recommend keeping files for 7 years is that some jurisdictions have specific rules or guidelines regarding file retention periods, and I think Kate touched upon this too, but some states require lawyers to maintain fee arrangements and trust account records for 7 years. While the primary reason I think is really for the lawyer's protection, it also ensures that if the client needs information from the file in the future, that the lawyer can still access it, even if it's been a while since the case was closed. So before destroying any file, lawyers should carefully consider whether the file is still needed to protect their client's interest and really to protect their own interest in case there is a malpractice claim filed later down the road.
This one question here, if your new firm insures you under their policy, do you still need tail insurance?
Kate, I can take this one since I know I quickly went over this at the end of the presentation. If your previous coverage is a claims-made policy, which most likely it would be, you may need tail insurance, also known as extended reporting period, ERP. I know there's a lot of insurance terms being thrown out here today. So if you're not sure what they are, jump on our website. We have a quick guide that explains what everything is. But this would depend on your new firm's coverage. So there's something called prior acts coverage. If your new firm's claims-made policy provides prior acts coverage, it will cover claims arising from incidents that occurred before the new policy's effective date, as long as the incidents are after that retroactive date specified in the new policy. In this case, you might not need to purchase tail coverage from your previous insurer. However, if the new firm's policy doesn't offer prior acts coverage or there's any gap in your coverage, you may need to purchase tail coverage to protect yourself from claims related to work you did while under their policy. So If you think you need an ERE or if you have more questions, again, contact AppPro, jump on our website, and this will kind of explain the right coverage, and it will explain all those insurance terms that can get a little bit confusing.
Thank you very much, Erin. At this point, we are out of time for further questions, and that will conclude today's event. On behalf of Attorney Protective, I would like to thank you all for joining us for today's webinar. Special thanks to our speakers, Erin and Kate. Thank you so much for joining us, and have a great day.